Family Law in 2025, Trends, Case Law Updates, and Legislative Changes with Aaron Franks and Adam Prewer. This session has been accredited for 30 minutes of professionalism with the Law Society of Ontario. Today, the panel will discuss an overview of current trends, recent legislative changes, and case law. And all resources mentioned today will be included in the show notes, which you will receive via email later this week if you have registered. If you have not, they will be in the YouTube description of this video. And I will now introduce the panelists. Aaron is a family lawyer. He is a partner at Epstein Cole LLP. And Adam is a partner at Epstein Cole LLP. He was called to the bar in 2013 after completing his clerkship to the Senior Family Law Justice, the Associate Chief Justice, and the judges of the Ontario Superior Court of Justice. Adam co-authored Unpacking Family Law for Practitioners with Justice M. Kraft. I will now hand things over to Aaron and Adam to get started with our first session of the day.
Which I was involved would be accredited for anything having to do with professionalism. But hey, there's a first time for everything. My apologies. I woke up this morning with a bit of a head cold, so I will try to not huck too much. Adam and I are doing the case law and legislative update, and fortuitously for all of us, there have been some recent legislative updates, very recent legislative updates. So I'll talk about the most recent, and then I will pass it over to Adam, who will talk about some of the other rules updates and things. So the most significant update is that without a whole lot of advance notice or flash or fanfare, the child support guideline tables were updated. They were updated last week. They were just published in the Canada Gazette without any notice that they were coming. And the new tables are in effect as of October 1st. So there's some instant work for family lawyers as the table amounts automatically change in pursuant to the guidelines. Anything that causes a change in table amount is automatically a material change. That said, the numbers actually don't change at a terrible amount. Some numbers, some income levels see support go up a bit. Some income levels see support go down a bit. By mandate, the guidelines are supposed to be reviewed and renewed and redone every 5 years. The last time this was done in 2017. So sort of typical government. We're a little bit late, but there they are. And as I say, and not even the calculation services like DivorceMate were told that these were coming out, so they're busily changing all their spreadsheets and all their programs and everything to make it work. Right now, the only way you can find them is actually in the Canada Gazette, or maybe by this point they've now been published. And just when people see them, the first thing they say is, "Well, I don't understand why there haven't been any changes. The cost of living has increased significantly." And you have to remember the guideline changes are not based on cost of living. The changes to the guideline numbers are based solely on income tax changes over the period since the last update. Because if you think about it, cost of living increase one's income as well as the cost of living, so both rise in tandem. It's the tax changes that haven't been since the last update that wouldn't have been calculated, and that's why some income levels see support go up, some income levels see support go down, and why some provinces actually see some rather significant changes. Alberta, for example, their numbers have changed because they've gone through some significant tax changes in the last 5 years. Ontario, not so much. So that is sort of the most significant and newest update in terms of legislation. Adam, what else we got?
So Ontario, in the past year or so, is now part of the Hague Convention on the International Recovery of Child Support. So if you are dealing with an international child support case, you've got new forms to fill out, and the family law forms were updated to reflect that. There were some changes in terms of the wording of the how to get a restraining order under the Family Law Act. And in terms of our rules, that is probably where everyone should pay the most attention, because last summer, the family law rules were changed. We've got some specific things, including that you are now allowed to sort of ask for money in the event if someone has breached an order to encourage compliance. The rules now explicitly prevent out-of-court are communications with the court that you've not sort of worked out with the other side. So that is now a specific rule under the family law rules. We have seen the incorporation into the rules of binding judicial dispute resolution in the past year. And what is very important is there's been a number of changes about costs in the rules. Specifically, there is now a requirement under the rules that lawyers confer about costs prior to an appearance. It's on the confirmation forms as well. In addition, the cost rules have been changed such that there are now sort of default page limits and timings for cost submissions. So if you do not address this at the end of a motion and it is just in accordance with the rules, you want to pay very careful attention to how much time you have. The time period is sort of pretty limited, and the page limit is very short for written cost submissions. So learn to be brief in your cost submissions.
That's A2. That's it.
That's A2.
All right. That is all for our legislative updates and all for the French that we'll be using during our presentation today. So Adam and I are going to go back and forth on some cases of note that have sort of arisen over the past year. These are certainly not all the important cases, but they're certainly some of the more interesting cases. And you will be getting I think you've already received a copy of the written material. So if any of these cases sort of pique your interest or sound like they might be of interest to a case that you have ongoing right now, you're welcome to sort of read a little bit more depth. So the first case that I'm going to talk, and Adam and I are just going to go back and forth. The first case I'm going to talk about is a case called Metzke and Metzke from the Ontario Court of Appeal, 2025 ONCA 418. As I say, you'll get the full cites and a brief write-up for each case. And Metzke is a case about proprietary estoppel. One of the estoppels that we don't deal with all that often in family law. But there are of course many estoppels. There's promissory estoppel, issue estoppel, estoppel by conduct. Proprietary estoppel isn't one that we deal with all that often. Now, Metzke involves a family, but it isn't a family case per se, but certainly it's something that family lawyers should know about, because sometimes it can slide in where other doctrines like unjust enrichment don't quite work. So what happened in Metzke is that Martin and Roseanne operated the dairy farm. They've been operating it for quite some time, since the early 90s. They decided to eventually sell their dairy herd and their dairy quota, but to keep sort of the cash crop part of the business. Martin and Roseanne had a son from whom they were estranged, Tim. Tim had a partner, Amanda. And although they were estranged, there were some discussions about perhaps Tim and Amanda coming in and buying the farm, or at least part of the farm business, including the herd and the quota, perhaps not the cash crops. But at that meeting, they hatched a plan. Martin and Roseanne and Tim's partner, Amanda. Tim and Amanda were going to buy the dairy herd. They were then later going to acquire the quota and the land at market value. And the purchase was going to be deferred for at least 5 years because they didn't have the money to purchase it up front. They never actually discussed a firm land price. The number of sort of $2 million for the land and quota was sort of thrown around and sort of used as a placeholder, but certainly no agreement was ever actually reached. And the thoughts of financing were then postponed. In the meantime, Tim and Amanda left their jobs, moved to the farm, and began running the dairy operation while paying rent for the barn, paying rent for the quota, and paying rent for the housing. They eventually bought the herd using a $90,000 bank loan. In 2013, they tried to get financing to buy the quota, but they were unsuccessful, and the financing fell through. Over the next several years, further disputes erupted between the parties. The first was a fight about whether or not Tim or his parents would have to pay for the barn repairs. The second involved criticism by Martin and Roseanne about how Tim was running the herd and herd management. Eventually, things went sideways, as sometimes they do in families, and Tim and Amanda actually even considered going to lease another farm, although nothing ultimately came of it. And that was the end of the discussions. The prices for the quota and the land still remained undetermined. There were no further negotiations, and the court at first instance found that Tim and Amanda could not have raised the money they needed in order to buy out the rest of the farm and the quota in any event. Finally, in 2018, after another heated dispute, Roseanne gave Tim and Amanda their marching orders, said, "Get the hell off my property." They complied. They sold the herds that they previously purchased at a loss because they no longer had the quota to support it. Later that year, Tim and Amanda sued Martin and Roseanne for $1.3 million for unjust enrichment. Martin and Roseanne, of course, denied liability and countered for their own lawsuit for some unpaid amounts that were supposed to be paid under their sort of lease agreement. The trial judge dismissed the unjust enrichment claim. He basically found that there had been no enrichment, had been no deprivation. Without enrichment and deprivation, you can't find unjust enrichment. However, the trial judge, upon hearing this, thought, maybe there's something else here, and started to consider ex proprio motu, as we say in Latin, of his own motion. This idea of proprietary estoppel, always a dangerous situation, although here for a judge to sort of raise their own claim, but here it was done right. He raised it. He gave counsel an opportunity to research and make submissions on the matter, and that's exactly what happened. Ultimately, it was determined that there may or may not be a proper claim for proprietary estoppel. Ultimately, the Supreme Court of Canada has the leading case in proprietary estoppel, a case called Copper, Smith and Morgan, which was decided in 2017, that's cited in the paper. The test for proprietary estoppel was set out very clearly by the Court of Appeal in this case: a clear representation or assurance leading to a reasonable expectation of a right or benefit over the property, reasonable reliance on that expectation by action or inaction, and resulting detriment that makes it unfair to the promisor to renege. So your typical sort of equitable estoppel doctrine, where you lead somebody down the garden path, you give them representations, you cause them to rely on it, you cause them to change their positions, and then you change your mind. The assurance can be expressed, can be applied, it can be clear, it has to be clear, it has to be unambiguous, and it has to be taken seriously. Here, ultimately, the Court of Appeal found there were three flaws in the trial judge's reasoning, who did ultimately find that there was a basis for proprietary estoppel. First of all, there had been no clear representation. At the very most, there had been a willingness to negotiate. The actual payment terms had never been actually set in stone. There was never anything set in writing. Ultimately, an agreement to agree was the most the Court of Appeal found was there. An agreement to agree is not an agreement at all. There was no actual representation, no actual assurance, and simply the quote-unquote negotiations were far too up in the air and far too loose to actually form the basis of any actual estoppel. Secondly, there was no reasonable reliance. Early on in the piece, Tim and Amanda knew they couldn't finance the quota. They knew it. They didn't disclose it. But that's the reason no further talks ensued, because they knew that they actually didn't have the financial backing in order to do it. And finally, there was no actionable detriment. Without any sort of promise to rely on, or any sort of alleged losses, any claims for losses were speculative and nothing else. Ultimately, the Court of Appeal made it very clear that in some cases, Metzke mirrors family law disputes, where handshake deals or wishful thinking are sometimes tried to be bootstrapped into an actual deal. And it's very clear now that if anybody's going to be claiming proprietary estoppel in a family case or not in a family case, you need a clear, concrete promise, you need to show reasonable reliance, and you need an actual proven detriment. So an important case to read, and it's one of those doctrines that is very applicable, as I say, to family cases sometimes. And sometimes when unjust enrichment fails you or resulting trust fails you, it may be the case that either promissory estoppel or proprietary estoppel can come in and fill the gap. Hopefully, however, you think of it on your own before the trial judge surprises you with it.
So I'm going to talk about a case called Wang and He, 2025 ONSC 3072. This is a case that's really useful for two things. First, it is a very effective summation of where we are in terms of what constitutes an urgent motion. And it's also an example of a case that you can cite when the other side is behaving badly. So in this case, Ms. Wang brought an urgent motion, and she was seeking parenting time on an interim basis. She was seeking exclusive possession of the matrimonial home. She was seeking in order that the child live primarily with her. And she expressed a concern that the father, Mr. He, would flee the jurisdiction with the child. This decision, however, was just about whether or not this would be allowed to proceed on an urgent motion. Ms. Wang had what, in terms of her narrative, she claims that she had fled the home because of verbal and mental abuse, but the very young child had been left behind. She argued she was the child's primary caregiver and she'd been breastfeeding the child, and that the father would abscond with him. The father, unsurprisingly, felt very differently. He claimed that there was no reason that she had to leave the home, that he was an adequate caregiver, and that the mother had left the child in his care for days at a time in the past. He argued that the mother was essentially over-exaggerating how much breastfeeding was happening, and he pointed out that the parties had hired a nanny and relied on that nanny so that the mother was not the primary caregiver. It's a very good case in terms of going through the considerations for an urgent motion. Of course, we have the Rosen factors, which were set out in 2005 and have been considered many times in Yale and Scarborough, for example, and then in Thompson and Wobler. Ultimately, what constitutes urgency to supplant the need to have a case conference is a very narrow set of circumstances. In the Tippe case in 2022, the court has described as generally relating to situations involving abduction, threats of harm, or dire financial circumstances. This is also a case that sort of focuses in on the specific requirements, like, you do need to actually have evidence as to when the case conference will be when you are arguing a motion is urgent. Associate Justice Kamal in this case set out, which is a very pithy quote, but high conflict does not equate to urgency. And in this case specifically, there was actually no evidence that the father had any sort of intention to abduct the child. And you want to be very careful when you're in these sorts of cases that you don't over-exaggerate your case, that you stay focused on what you can prove. Because if you make a somewhat wild claim that you cannot back up, you're going to degrade from your entire argument. This is also a great case for dealing with situations where the other side is not following the rules. Counsel for the mother in this case had the judge noted, completely disregarded the consolidated notice to the profession for family and child protection matters in the Ottawa Family Court. So all of the materials exceeded the page limits. And this is a case that you can cite in a factum if you are arguing that the other side has exceeded the page limits. The other side had also, in a real wild choice on their part, they had brought a notice of motion on notice seeking an urgent motion, which they then withdrew because they couldn't have it heard soon enough. So they then brought it on ex parte, the exact same motion on an ex parte basis in order to get it heard sooner. Unsurprisingly, the judge said that that was not okay. There is some very clear direction to counsel in this case about controlling clients, that our opinions and our views of this are supposed to carry weight and credibility with our clients. And the privilege of being counsel comes with responsibility, and that is the responsibility to reduce conflict and maintain the integrity of the system. In a sort of a line that actually makes me extremely anxious, just reading it, something that I'd never want anyone to ever say about me, but the judge said in the final sentence of his ruling, as officers of the court, counsel need to act with integrity. Counsel for the applicant did not do so. You do not want to be in a situation where a judge says that about you. But if you are in a situation where the other side is acting badly around an urgent motion, Wang and he is a case to look at.
Thank you. So as long as we're talking about professional responsibility and professional integrity, that's simply too good a segue. I was actually going to skip the case of Como and Fox, but I'm going to talk about it a bit because it impacts the way we lawyers practice. We as family lawyers understand that sometimes we are not dealing with people at their best. Separation is a very difficult time. It's regularly compared to, or it's regularly suggested, sort of the second most difficult thing to having a death in the family. And we as lawyers deal with these people on a regular basis and try to help them. I will often tell my clients and my back office, the people at the back office at the firm, while I may be an okay lawyer, I'm a really shitty accountant, and I very often don't necessarily keep track of what retainers we have and what ARs are, and then that kind of stuff. It's just I just don't pay attention to it. Como and Fox shows that by not doing that, you can really get yourself kicked in the ass. So it's not at all unusual that when we have a difficult client, we will occasionally, not all the time, but very occasionally have a client sign a notice of intent to act in person, knowing full well that when things get difficult, the client may not cooperate. You may have to bring a motion. You may or may not be allowed off the record, depending on when in the proceeding you bring your motion. And counsel used to think, I emphasize, that you could simply have a client sign a notice of intent to act in person, and then whenever the client started to misbehave, you could simply bring it out, file it, and say, adios. So that was the situation that was presented to Justice Pazaratz. Justice Pazaratz starts his decision like this, and there's nothing better. I could just actually spend all my time reading the first couple paragraphs to Justice Pazaratz's decisions because they're often very, very pithy. So he says, if you sign this piece of paper, it means that any time I choose, I can dump you as a client. Even on the eve of trial, suddenly you'll be on your own in the courtroom. Lawyers are not allowed to say that or do that. A notice of change of representation is not the same as a get out of jail free card in the board game of Monopoly. It's not an escape hatch to be kept in a back pocket until the lawyer tires of the client or the money runs out. And Justice Pazaratz then, over the course of numerous pages, goes on to suggest what the problems are with lawyers undertaking this practice and having a notice of intent to act in person signed. It's a rather sharply worded endorsement. He suggests that doing so is a tactical misuse of the notice of change in representation, and that lawyers simply can't do it anymore. This situation was a woman had been represented for quite some time by the lawyer. A 6-day trial was scheduled for the July 25 sittings. At the trial scheduling conference, the lawyer remained on the record for the mother, gave no indication at all that she wouldn't be representing the mother at trial. Father was self-represented. In April of 2025, lawyers served father and mother with notice of change, one that had been signed by the mother more than a year earlier. So the lawyer here had done exactly that Justice Pazaratz said can't be done, indicating that the mother would then be representing herself. In July, the mother scheduled an attendance in purge court to request an adjournment of the then imminent trial, finding herself without a lawyer. She cited the fact that she didn't have a lawyer, cited the fact that she couldn't understand the case herself, cited the fact that she was having trouble finding a new lawyer on the eve of trial, and suggested that she was wholly incapable of running the trial on her own. The father opposed the request. At the purge court shows up Justice Pazaratz, who invited the lawyer to show up via Zoom to clarify the timing of the notice of the delivery of the notice of intent to act in person. And when I say Justice Pazaratz invited, well, we all know what a judicial invitation means. So the lawyer showed up, quickly understood that this was not going to go well, got back on the record, and did the trial, even though can't tell entirely, but I'm guessing likely wasn't paid for her services for trial at the end. But Justice Pazaratz does take the opportunity to talk about the situation and the fact of unbundled legal services and limited scope retainers and such, and the sort of this thing where lawyers will appear as agent only, but not on the record. And Justice Pazaratz takes a very sort of judicial view of this, or from the point of view of the judiciary, which one might think, and says, listen, this is no way to run a railroad. How does it work if every time this case shows up in court, there's a different agent or a different person offering limited scope retainer services? On Monday, lawyer shows up and undertakes to do something, and 3 weeks Monday, a different lawyer shows up and says, I had no idea that this promise was made. He says it's simply no way to run a railroad. But Justice Pazaratz, I may forget, I say with the greatest of respect to a very well thought of jurist, is what it means to be a lawyer. And would it not be better that somebody shows up with some assistance, be it by agent or unbundled legal services or limited scope retainer, than showing up alone and simply drowning in the procedural morass of our current rules and current notices to profession, etc. That is a part of the point of view that Justice Pazaratz doesn't talk about. But as a result As a result of this, the most important thing that Justice Pazarat said is that there is a temporal element to a notice of change, and you can't simply have somebody file one time and then serve it a year later. It's something that has to be done quite immediately, and in fact, if you try to do this, the court may actually step in and say, no, you can't. So this is the reason I say that lawyers now have to start to pay more attention to their accounts and more attention to their receivables, because if you think that you can simply, as trial approaches, get off the record, either by motion, which Justice Pazaratz also talks about, or simply by whipping out a notice of intent to act in person that you had signed sometime before, it's entirely possible that's not going to be successful. And if that's not successful, you are facing the prospect of doing a trial of 1 day, 5 days, 2 weeks, a month without getting paid, which is a prospect that nobody particularly wants to think about. So as trial approaches, months and months and months before trial actually approaches, you should really be giving this some thought and thinking, is this a client I'm prepared to take to trial? Do I want to get my trial retainer now? Do I want to make sure I get it months in advance to avoid exactly this sort of situation? And the thoughts of getting a notice of intent signed now, at least, and using it sort of at your will when you need it, seem to have gone by the wayside, even though I say again respectfully, I would think that many judges would rather have a lawyer on the record for as long as they can be on the record with the protection of a notice of change if they need it. Because let's face it, the only time we get these notices signed are when we have a client who's proven to be disobedient in the past. So it's an important read, a concerning case, but it is the law.
So the case I'm going to talk was actually from Nova Scotia. It's DP and FM. This is a case that is about interim motions for parenting, though this is a very unique interim motion for parenting. This interim motion had a 2-day hearing featuring viva voce evidence from both parents, multiple collateral witnesses, and both parties were subject to cross-examination with written submissions filed after the close of evidence. So a very thorough hearing, which may help us understand, because in this case, a 16-month-old who had previously been living primarily with the mother is involved, and the judge orders a 50-50 shared parenting arrangement. This is a case that deals with a number of those important issues when you deal with a child of this age, specifically things about the status quo. Justice Mason deals with a status quo here that the court finds was imposed by the mother. However, the judge also deals with the fact that the father would frequently breach the sort of imposed agreement on him. This is a case that has a lot of great analysis, even for courts and lawyers here in Ontario, as Justice Mason does a helpful review of the key principles, including talking about Justice Pazarat's often cited decision of Churchill, Elliott, and Ward, which we talked about last year. And I would encourage everyone to read. It has 40 core principles for interim parenting disputes, and in many ways is the only case that you need. But this case is also very helpful, particularly in dealing with the concept of a status quo and whether that status quo is placed on you or not. The court put a lot of emphasis on the fact that the mother had essentially resorted to self-help, that she had imposed this plan, and that the court will not sanction parties who act in such a manner. The mother had unilaterally restricted the father's time. Though that being said, after cross-examination and all of the evidence came out, it appeared that the parties actually had fairly good things to say about each other in terms of their actual parenting skills. Indeed, on cross-examination, both expressed confidence in the other parent's capacity and their ability to cooperate moving forward. So as a result, the court felt comfortable that the father could sort of build up in a very short period of time to a full 2-2-3 rotation. Aaron and Michael, in their write-up of this, posited that we will likely never know how this turns out. because we just touched these cases and we never found out the background. But it would be very interesting, given that it was a significant shift. The child had lived primarily with their mother for their entire life, and this would be a seismic shift in their sort of experience. However, given the process, it's clear that the judge had thought about this a lot, had considered the factors in Nova Scotia's Parenting and Support Act, which is very similar to our Family Law Act, and determined that both parents were capable of meeting the child's needs and that this would be in the child's best interest. It's also an interesting case to sort of look at historically, as in the not too distant past, we would have been thinking about this under the tender years doctrine, in which case a decision like this would never have occurred. So a very interesting case, an important one for interim motions on parenting. And even if it's Nova Scotia, still one that touches on a lot of good Ontario case law.
What do you mean, even if it's Nova Scotia? You just insulted an entire province of our Dominion.
Yep, that's usually what I do at least once in these things.
I'm going to talk about a case called Chapman and Ing, which deals with the marriage of family law and corporate law. And there's a lesson buried in here somewhere, and I'm not entirely sure if the lesson is don't do business with those you're sleeping with or don't sleep with your business partners, but there's some lesson in here. You can decide what it is for yourself. The parties were engaged sort of in the typical on-again, off-again relationship for several years. To complicate matters, they were also business partners in a trucking business and in a property holding business. They used various structures to buy and sell these properties. Over time, their personal relationship really soured and went sideways, as often does when the personal relationship soured, so did the business relationship. And then the parties then disagreed as to their entitlements in both the corporate world and the family law world. The appellant, who was the male in this case, wanted an order for the windup of the parties' mutual real estate companies and the appointment of a receiver, arguing that he was entitled to half of everything, half the proceeds, half the company, as he was a 50% shareholder. He argued that the parties were in a joint family venture. This is where the family law lawyers get interested, and that he owned the properties on a 50-50 basis, regardless of title. The trial judge disagreed and found the parties were less intimate partners in a joint family venture and more business partners who from time to time engaged in unbusinesslike activities. He found that they were in a conjugal relationship, although really just barely. They found that the split proceeds equally would be to unjust enrich the appellant because the value of one of the properties had significantly increased after separation due solely to the respondent's investment of time and money. And then having not contributed, he wasn't entitled to share. The trial judge therefore awarded the respondent a 100% interest in the property, in this one specific property at issue called the Wyandotte property, in exchange for a rather nominal payment of $39,000, which was essentially 50% of the purchase price of the property, less the amount of the first mortgage. The appellant, as many appellants are, was unhappy. Otherwise, they would not be appellants. He trotted off to the Court of Appeal and came up with a new argument, a clever argument, and said, hey, everybody have a look at Section 22(3)(b) of the Ontario Business Corporations Act that basically says that an equal shareholder in a corporation is entitled to equally share in the property upon wind-up or otherwise. He suggested the trial judge erred in granting a proprietary award when a monetary would have sufficed. And lastly, he argued the trial judge erred in valuing the remedy on a value survived basis, given the fact that the parties were not in a joint family venture. So this is a fairly meaty case to unpack. Parties first were in business in 2007. As I think I may have mentioned, they had a trucking company, they had a property company. When things soured, the husband essentially stripped the trucking company, sold a whole bunch of the trucking company assets to friends at below market value, started another company and started transferring clients to the new company, basically behaved in all the sorts of ways that you do not want your clients to behave when you have a suspicion that you may land up before a judge. So that left the Wyandotte property that had actually done really quite well, solely on account of the, I will call the wife's efforts post-separation. Again, the trial judge found that the parties were in a conjugal relationship that eventually became predominantly focused on their business. And while the marriage was certainly not at all happy, it was still a conjugal relationship. The trial judge also found that the appropriate remedy would be to require the respondent to buy out the appellant shares in the company as those shares exist at the date of separation, and that's where the order of the $36,000 or $39,000 payment came from. Notably, this case relies heavily on Milotovich and Pennington in order to figure out whether or not the parties are in a conjugal relationship. The court doesn't consider Kasabian, a case that came out just after this case, which we're actually going to talk about a bit later today. That is sort of the new leading case on when on whether parties are in a conjugal relationship and when the conjugal relationship ends and when the parties have separated. In analyzing unjust enrichment, the trial judge found that the appellant had been enriched from the respondent's investments, and therefore she was to enjoy most of the benefits of the property that she worked on to avoid an unjust enrichment. As I say, husband comes up with this novel argument about a juristic reason for the enrichment, because remember, enrichment requires an enrichment, a deprivation, and lack of juristic reason. So husband said, well, maybe there was enrichment and maybe there was a deprivation, but there is a juristic reason, and that juristic reason is the OBCA, specifically, can't remember the section number, but the section I referred to before, section 2022(3)(b), which says rights of shareholders, where a corporation has only one class of shares, as did this one, the rights of the holders thereof are equal in all respects and include the rights to receive remaining property of the corporation upon dissolution. He said based on that, there was actually a statutory juristic reason for the unjust enrichment, and therefore there could not be a finding of unjust enrichment, and the proceeds were to be divided equally. The Court of Appeal, first of all, deals with the fact that this was a new argument raised on appeal. And while the Court of Appeal is very loath to entertain new arguments on appeal, here they said, well, really, this is simply a new legal argument. There's no new facts that have to be brought to bear. All the facts were already out. And therefore, they did allow the argument on appeal to be made on appeal, even though it hadn't been raised below. However, Justice Pomerantz said, while a good shot, 22(3)(b) of the OBCA does not provide a juristic reason for the enrichment, and the reason is predominantly because if a statute is meant to is going to be used as a juristic reason to avoid unjust enrichment, it has to very clearly say so. According to Justice Pomerantz, by its term, Section 22(3)(b) addresses the relative rights of shareholders of the same class vis-a-vis the corporation. It does not purport to allocate the family law or equitable claims that one shareholder may have against the shares registered to another shareholder. There's nothing in the section that can account for the enrichment of one shareholder to the detriment of another, even if linked to their corporate dealings. The provision is immaterial. So Justice Pomerantz says, yes, by all means, at corporate law, yes, equal shareholders are entitled to equal rights. However, there is this sort of overriding family law jurisprudence in the background that we have to pay attention to. She then goes on to remind us all about the case of Wildman and Wildman, where the court says this is particularly so where the context involves family law litigation. In Wildman, the court was willing to pierce the corporate veil in a family law dispute, commenting that this is matrimonial litigation, not commercial litigation. So that is music to a matrimonial lawyer's ears, and it's a very useful phrase to bring out whenever you happen to be in a case that does involve corporate litigation, because family law sometimes is just different. And there have been a number of appellate authorities that actually say just that. Ultimately, on the just by way of subnote, it's not certainly the most important part of the decision, but Justice Pomerantz does suggest that the trial judge may have erred in ordering a proprietary remedy, being a trust interest, on a value survive basis, even though a joint family venture had not been found. And in suggesting that the trial judge may have erred, I respectfully suggest that Justice Pomerantz actually erred, because you have to remember how things were before Curran-Barano. Before Curran-Barano, for unjust enrichment, the first award, or the award of first resort, was a monetary remedy. if a monetary remedy was found to be inappropriate for some reason, or insufficiently linked, you could then go on to a proprietary remedy. Before Curran-Barano, the whole idea was that a monetary remedy had to be valued based on value received, and a proprietary remedy had to be valued based on value survived. Curran-Barano sort of undid those strict sort of silos and said, no. If there's a joint family venture, you can also award monetary relief, which is again the first grounds of relief, and you can value it based on value survived, which tends to be a much higher value than value received. So that was the purpose of Curran-Barano, but it does not mean that you can only value something based on value survived if there is a joint family venture. Curran-Barano didn't undo the fact that generally speaking, a proprietary remedy is valued based on value survived. So that's just a little bit of a hiccup in the analysis. And if you are not reading it, knowing about that, if there's a possibility of getting confused. But a very important case to read up there with Wildman and Lynch and Siegel, where we're talking about sort of the differences between family law and corporate law.
So I'm going to talk about a case called Scott and Scott, which is a cost decision. This is a case that is very useful when you are dealing with costs related to unproven and spurious allegations. So here, the parties had a trial, and the wife had been successful in all issues and was seeking full recovery costs of just over $57,000. She argued that the husband had been acting in bad faith. The family law rules allow for full recovery costs in the event that a person acts in bad faith. From the case of Scalia and Scalia, we know that essentially the components for bad faith are that you have an intention to inflict harm or to deceive. That's the core of bad faith under the family law rules. So what was the bad faith in this case? The husband argued that the wife had been collecting millions of dollars over the past 10 to 15 years because she was in secret an internet porn star named Princess Consuela. To prove this, he provided 39 images that he claimed depicted his wife that he had captured from the internet. The issue is that none of the pictures showed her face. Query as to how he identified this individual. The judge was not impressed by this argument, described it as being patently ridiculous, also pointed out that the independent witness called by the husband had no credibility whatsoever, and that everything was a deception, piling, quote, improbability upon improbability. So very clearly to the court, they saw this as a concocted argument. It was designed to humiliate and embarrass the wife. She was forced to deal with these, quote, absurd and unfounded accusations for years through the litigation process. And this was done as a form of revenge. So this is one of those situations where it can be very useful when you are making these cost arguments in terms of claims that people are making that have no basis, that are there to drive up cost, to embarrass and humiliate. So an important case for that point, and I will turn it back over to Aaron.
Some cases you read and you think to yourself, wow, I wish I was there for part of this one. This is one of those cases. I would have liked to have been there for the cross-examination regarding Princess Consuela, but alas, I was not. I'm going to talk about a case called Q and Zhang that deals with the presumptions of resulting trusts that are baked in to the Family Law Act in Section 14. And it was meant to answer the question, although, as we'll see, it doesn't actually answer the question, is there a difference in funds that are received before marriage and after marriage? Because before marriage, parties aren't spouses. So Section 14 doesn't apply because Section 14 is in Part 1. And Part 1 adopts the definition of spouse of parties that are married or party to a marriage that's void or voidable in good faith. So prior to marriage, we're left with the doctrine of resulting trust, which is, as we all know, that parties buy something or transfer funds, and the law presumes bargains and not gifts. However, after marriage, we have section 14 and the subsections that say money that is held, property that is held jointly is presumed to be held as joint tenants and meant to be held as joint tenants, and money in a bank account that is in a joint account is presumably meant to be held jointly, subject to proof to the contrary. So the burden of the presumption switches as you walk down the aisle, which is something nobody thinks about as they're marching down the aisle. And the question then becomes, if money is advanced before marriage and the parties then separate after marriage, does the nature of the obligation change? Does the nature of the presumption change? Are we stuck with the originals, with the original presumption of resulting trust, with the person receiving the gift having to produce evidence to rebut it, or are we now in the switched regime under Rule 14, where the assumption is that there is actually meant to be equal holdings, and the person that's contesting it then has to hold it? The facts of the case are somewhat unremarkable, and the factual background or factual matrix is exactly as I've described. One of the parties kicks in a fair amount of money to the purchase of a property that is ultimately registered in joint names. This is done before marriage. After the parties are then married for a very short time, then there's a separation, and the question becomes, well, who bears the onus of the presumption? Does the person that gave the money, are they able to say, well, this money was given before marriage, therefore a recipient has to show that a gift was intended? Or because we're now married, do I lose the benefit of the presumption and I have to do it, and now I now have to deduce evidence to show that I never intended a gift at the time? Ultimately, although it would have been really great to have this question answered, because it remains sort of one outstanding question, and because the Court of Appeal does suggest, maybe in a case called Holtby and Draper from 2017, in one paragraph does suggest maybe that the presumption doesn't switch. Ultimately, Justice Trotter adeptly dodges the question and says, listen, on the facts of this case, it doesn't matter if we apply Section 14 or if we don't apply Section 14, because even if the wife bore the burden of presumption, bore the burden of the presumption, having given the money under Section 14, she discharged her burden. Therefore, it wasn't necessary to consider whether or not this one particular passage from Holtby and Draper sort of stood for this proposition that once married, Section 14 applies to even pre-marriage gifts and the like. So it would have been nice to have the answer. We don't entirely have it. As Justice Trotter notes, in a perfect world, litigants would carefully document their financial affairs, but we as family law lawyers, that, the reason we do some of what we do is specifically because we don't live in a perfect world, and people don't always live in perfect marriages. So the court below ultimately bought what the wife was selling, even if it was mostly her that was selling it, because she was the only one that gave evidence, which also raises the point that this the clear and convincing evidence that you have to raise in order to rebut a presumption can actually come from the party themselves. You don't necessarily need third-party evidence. The Court of Appeal also talks a bit about occupation rent and really sort of hammered the husband here by way of occupation rent, which tends to be how occupation rent is used these days by the Court of Appeal, especially since Non-Shum and Green, where they really loosened the reins on occupation rent and said, yeah, it doesn't have to be unique. It just has to be a reasonable situation. And here the Court of Appeal agreed that the husband's conduct had been so egregious, they essentially used it to offset a fair amount of what he otherwise would have been entitled to receive. So an interesting case, doesn't answer quite the question we'd hoped it answered, but it does take a little chunk of it anyways.
So I'm going to talk about two cases sort of mushed together, just as we're running a little low on time. It is DuPont, Good, and Ashmead, and Kaniga and Thwaites. So in DuPont, Good, and Ashmead, this is a case that sort of stands for two broad things. And the first, it's by Justice Sharma. There's a big chunk of it about how you should prepare materials for a motion. And if you have issues with the other side in the preparation of their materials, this is a good case to cite. Justice Sharma goes through all of the potential issues, from the fact that an affidavit should be in first person to that you should proofread your affidavits. Also, you are not allowed to attach another person's affidavit as an exhibit to the first person's affidavit in order to get around page limits and things like that. So a very useful case in that respect. Then His Honor does something that's very interesting, which is this was a parenting case, and His Honor talks about the fact that there was no independent and objective evidence from the Ontario's children's lawyer or other parenting assessor of what's best for the children in this motion. And there was no expert evidence as to what was best for children of this age. And what he states is, in the absence of such evidence, I refer to the AFCC Ontario Parenting Planning Guide as independent and objective evidence of what is best for children. So while we have talked about in the past judges using this parenting guide as a guideline, and it is seeing increasingly large or an increasingly wider adoption in courts, this would appear to be a court taking judicial notice of the parenting plan guide itself, which is something that is likely outside the bounds of what can be taken judicial notice of. Essentially, the facts have to be so notorious or accepted that everyone in the community accepts it as being true. It's not the subject of dispute, and I don't think this reaches that level that the guideline can be used in such a way, but it is a further example of seeing how far the parenting plan guide has spread, and it's important. It would also indicate that this is a case where a judge was really struggling with the lack of evidence and averts to something when they are trying to make a decision for the best interest of the children. It's also potentially a little troubling because judges are supposed to make a decision on the best interest of the kids in front of them, not children generally. And if the AFCCO parenting plan guide sort of has this automatic default position, then that would indicate it sort of is a general proposition about kids rather than a specific one. So compare that with the Kaniga decision with Justice Tweedy, where Justice Tweedy deals with the same guideline and specifically states that it is only a guideline and cautions against parties considering it a default position. In that case, the mother had behaved very badly. She imposed a parenting schedule on the father. She also broke into the father's house and then subsequently broke into his computer to find out if he was telling the truth as to why they couldn't spend family day together. This was post-separation, and she was actually convicted for an offense under Section 342 of the Criminal Code, which is unauthorized use of a computer. And as family law lawyers, we know a lot of people who are using the other side's computer in an unauthorized fashion. The AFCCO parenting plan guide is cited directly in this case. This case sets out very clearly that it's just meant to be a guide, though it is an extremely helpful guide. So Justice Tweedy departs from it. The mother argued that while she had imposed the schedule was appropriate for the age of the child based on the guide. This case is also important, and it's very interesting because a lot of parents, particularly with a child of this age, because it was another case with a young child, the mother here argued that she'd been the sole decision maker for the child since birth, and that status quo should continue. She should have sole decision making. Justice Tweedy didn't accept this and noted that it was a status quo imposed on the father. The mother had made all the decisions because she didn't let the father participate. And a self-engineered status quo is no status quo at all. The mother was not fully supportive of the father's relationship. The father was supportive of the child's relationship with the mother, and he was the more successful party. Joint decision-making was ordered, and the father got a schedule very similar to the one that he proposed, which did depart from the guide. So an important case on two important cases on the AFCCO guidelines and how we consider status quos.
Okay, we are indeed running short of time, so I will speak quickly about a couple cases and just sort of hit the high notes. Marillion and Dunmore, the case that keeps on giving. It's now been reported 5 or 6 times for different issues, most recently from the Supreme Court of Canada. the Supreme Court of Canada deals with this situation. You are a lawyer, you have a client, your client shows up in Ontario with a child. The other side suggests the child is in Ontario improperly. Hague Convention, you're thinking, but no, because the jurisdiction from which the child has most recently come is not a signatory to the Hague jurisdiction. Therefore, the Hague doesn't apply. Therefore, we're dealing strictly with the Children's Law Reform Act. Therefore, what is the test of habitual residence under the Children's Law Reform Act as opposed to the test of habitual residence under the Hague Convention, which comes from bailiff? Bailiff, a case that I don't like. Bailiff dealing with habitual residence in the test that I don't like because it deals with the whole hybrid approach rather than deviating from, rather than the old sort of parental intention approach. In Merlin and Dunmore, the Supreme Court of Canada says that while the definition in bailiff of habitual residence does not apply directly to cases under the CLRA, similar conditions may still inform the analysis. Habitual residence under Section 22 of the CLRA does not require a shared parenting. It does not require shared parent intention. They then give a couple high notes about what you do look at in order to determine shared parenting. You can read bullet points as well as I can, so I will simply leave them to you. It was a bit of a surprise that the Supreme Court of Canada heard this case, having just heard FNN just a couple of years earlier, but FNN really dealt with the issue of potential harm under the CRA if the child is returned, and Merlin and Dunmore, at least this issue or this incarnation of the Supreme Court of Canada, specifically deals with that issue of habitual residence. Justice Cote, as she always does, dissents, like the dissent. Here, Justice Cote says the parental intention approach really has to play a central role in determining the habitual residence of a child, and she was concerned that the majority's rejection of that approach would incentivize parents to submit any and all evidence relating to the child's connection to a particular jurisdiction, and all that was going to do was extend the time it took for these cases to be litigated, and she's exactly right. Next case, again, just by way of high notes, is Versailles and Bauman. Versailles and Bauman is Justice Finlayson's attempt to try to undo the problem that we have where if a spouse is subject to a foreign divorce that is recognized, that spouse can then no longer claim support in Ontario, because you can't claim support in Ontario as corollary relief if you're subject to a foreign divorce, and you can't claim support under the Family Law Act in Ontario if you're a former spouse. Justice Finlayson suggests that it's time to sort of re-examine that whole former spouse issue under the Family Law Act, and he finds that, in fact, yes, it's time to redo it, and finds that, yes, he would have awarded support. Unfortunately, the problem or the warts with Versailles and Bauman are that only one side had a lawyer. This whole issue was really sort of raised by the court, a very well-meaning court by Justice Finlayson, who was really trying to address this problem, as directed by the Court of Appeal a number of times. The problem is it's really hard to undo 20 years, if not more, of jurisprudence that are very clear that say a former spouse can't claim support. So while it's a valiant effort and absolutely worth the read, I'm not sure it goes far enough. And finally, on the same topic, yet another incarnation of Merlin and Dunmore. This time, a constitutional challenge had been brought to the definition of spouse under the Family Law Act, on the basis that a former spouse can't claim spouse support. The end of the story is that here in this particular incarnation of Merlin and Dunmore, determined by Justice Mathern, who is actually a constitutional scholar, good case, good judge to hear it. She said, "Listen, unfortunately, there's just not the evidence I would need here to find that the definition runs afoul of Section 15, and I don't fault counsel for that. The problem is that this sort of morphed into a constitutional charter case halfway through the case, and it's really hard to take a case that isn't a charter case and just turn it into a charter case." The final case I can talk about very quickly is Kasabian and Markarian, the new leading case on what it means, on what data separation means and what reasonable attempts to reconcile means. And notably, it does not even once mention the term matrimonial consortium, because who the hell knows what a matrimonial consortium is? And that's from Oswell and Oswell, where one party breaks the matrimonial consortium. Kasabian actually takes a good hard look at past case law, and it is the case you have to read if you're dealing with whether or not parties have separated and whether or not there have been reasonable attempts at reconciliation. Sorry for the fast talk at the end.
I mean, I think that's our time, Russell. We're at 10:15.
Wow. What can I say? That we heard of a matrimonial consortium's child support updates. We've got 10 days or so to get that sorted. The marriage of family and corporate law. That would be an interesting ceremony. Couples taking care of business. well taken care of business. That's always fun to read those ones. We've heard about princesses today. I might have to go try to find that princess online somewhere. Would have been an interesting case to sit
Just
in on.
Consuela.
Self-engineered status quos. Aaron's told us about unhappy appellants. Is there ever a happy appellant? I guess if you win,
I
right?
guess only at the end of the day.
Right. Um, what I really liked was this discussion, Aaron, about to control clients, right? And then now Form 4 is kind of dirty business, if you're going to use that to try to control your client. But there's practical realities for our clients. They may not have a trial retainer ready when you're setting the trial. And counsel can't simply just adjourn the trial until the retainer's in place. So I guess my question is, what are some tips in terms of, trying to get a proper retainer, controlling your client and your duty to the court? What practical tips do you have for lawyers out there?
Well, I guess tip number one is what I was told a very long time ago, and I think it was actually by Ian Hull, who's a senior estates lawyer. And he said it's wonderful to do pro bono work. And our firm does a lot of pro bono work, but it should be the lawyer that decides if the case is pro bono and not the client, which is actually very good advice. Let's face it, legal fees are expensive. Sometimes clients and lawyers are mismatched, and you don't necessarily always need, the Cadillac or the highest. Sometimes, a solid Volvo was really all you need. And the other thing that I mentioned is that, you really sort of, as the case winds forward, you really have to sort of take some responsibility for financial management. You have to know if your AR is creeping up. You have to put your client on a payment plan. If, once you're at trial, once you're heading to trial scheduling court, like, that's what happened in Justice Pazratz's case. Like, this lawyer went to trial scheduling court and made no mention of the fact they were going to get off the record, and then tried to get off the record immediately after. So I think you have to have these discussions with your client long before a trial scheduling court. You have to say what the retainer is going to be, and you got to get your trial retainer in early. If they can't afford your trial retainer, then you can discuss if you're going to do some sort of unbundled services. But while on the one hand it is incredibly unfair to lawyers to force them to stay on the record and do a trial that could last, in a parenting case, a high conflict parenting case, it could last a month. Like, to do a trial like that and not get paid for it unless you're doing it voluntarily. On the other hand, yeah, I get what Justice Pazratz is saying, and you got to make these plans early. So you got to have some sort of tickler, or you have to have your assistant remind you, hey, the Smith trial is, the trial scheduling conference is coming up next week, and you're owed $25,000. Do you want to have a discussion? Do you want to think about it? Because at some point it's going to be too late, and no one's entirely sure when the too late point is. So you gotta keep an eye on things. That's my best advice.
A lot of lawyers couldn't afford to do a 30-day trial and not have the income.
Right. It would be financially ruinous. It would be the end of the practice, right?
Yeah. So in terms of, Adam, do you want to add to those tips? So that was great, Aaron.
I mean, I don't have much to add other than just, I guess you have to know yourself. If you're the kind of lawyer who isn't good about tracking those things, then you need a good system in place or a really good assistant to sort of deal with that. Aaron made the joke about, he's not so good at that back end, but he's very good about making sure that he has an assistant and systems that make sure that that makes up for that part of it, which lets him free to be the excellent lawyer that he is. So you don't have to do all of that. It doesn't have to be your personal thing, but you need to be aware of it. And if that's something that you struggle with in your practice, put in the things in place to help you. Don't feel like you have to do it all yourself.
Yeah, great tips. Can you discuss briefly, you mentioned the temporal element to the notice of change. Are we talking hours, days, weeks, months? And what if you're at an exit pretrial and your client didn't fulfill his or her agreement to provide you with the trial retainer? Is that too late? Are you stuck at that point? What would your take on that be?
So there's sort of two questions there. One is, what's the temporal basis for filing a notice of an act in person? And number two is how much time is not enough time in order to get a judge to allow you off the record. So the first question is, like, if you have a client sign a notice of intent can you wait an hour, a day, a week, a month, a year? Justice Pazaratz doesn't give a hard and fast rule, but he certainly makes it clear that time matters. So I certainly wouldn't, I would have no difficulty saying, listen, Mr. Smith, you've shown you're not really that interested in following my advice. You owe me $20,000. I'm going to have you sign this notice of intent now, and here are the rules. Within 30 days, you must cut your receivable in half, and you must do 1, 2, 3, 4, 5, which are things you're ordered to do. And if you're not, I'm filing this. I think you're okay doing this, because doing that, there's nothing that says you can't use it as a hammer to try to, wrench compliance from a client, especially if you're trying to get them to comply with a court order. In terms of when you can bring a motion, if you have to, if you've got a hearing coming up, if you have a motion coming up, if you have a long motion coming up, or heaven forbid, if you have a trial coming up in the relatively immediate future, courts are giving lawyers hard times getting off the record, which is why I say that this has to be planned months in advance, not weeks in advance. If your trial starts in 2 months, you're going to have a hard time, especially if it's a peremptory trial, because the court's going to say, well, who are we going to find to represent this person? This person can't represent themselves, and we're not going to adjourn the trial again. So it's something added that lawyers have to think about. And then that, invokes the specter of law pro if things don't go right. And they're candid conversations. People don't like talking about money, but you have to, or you have to have somebody in your office do it, but it has to be discussed or you will get screwed.
Is the court sorry, go ahead, Adam, you want to jump in there?
It also probably makes a difference if you're the one bringing the motion to get off the record. Like, one of the things that sort of does seem to come out is if the court just finds out about this, right? Like, the judge finds out about this at the purge court because the mother scheduled attendance. Like, you don't have an opportunity to get in there and explain what's going on. I think a court's going to have more sympathy for people who are able to bring that motion. Though, again, to Aaron's point, that means pre-planning and acting in advance. You just don't want to be bringing this up at the exit pretrial to say, oh, by the way, I haven't been paid. I'd like out, please.
And after the fact, an invitation from a judge, it's not an invitation, because if you don't show up, it's going to be followed by a court order.
Exactly. And it is, what other profession can you be forced to work for free? Like, when I go to the dentist, the door is locked and barred until I pay for the dentist, right? But if you need surgery, perhaps not in Canada, but anywhere else, or anything elective, you pay, it's pay as you go. Only lawyers are sort of hung out to dry for, having the audacity to allow a client to carry a receivable for a while. So there's some unfairness in it, but, it's also a privilege to practice in the profession. So, it's a balancing act.
One last quick question, not just about money, but what if there's a change in, your client's temperament, or you're not following your advice, or they're instructing you to go on trial on issues that are not going to be successful? Would a judge let you jump ship then, or?
So that's an area that Justice Pazaratz does talk about, and he does make a point that if you show up in court and say, I have to get off the record, not for financial reasons, but for ethical reasons, either there's a conflict, a real conflict, like a conflict has arisen, or a client is no longer following your instructions or something like that, he then suggests that the court really can't make inquiries because it's a matter of privilege, and you're then entitled to get off the record and the court won't get in the way. But woe unto the lawyer who makes claims of breakdown of relationship or suggests that there are ethical issues if it turns out it is only a financial matter, because then you're even more screwed. This isn't the time to put your personal reputation on the line. So if there's a whole bunch of letters saying pay my account, pay my account, pay my account, pay my account, oh, I need to get off because we have ethical issues, and that comes out, that's not going to paint you in the best light.
No, good tip. Adam, anything further before we sign off?
No, just, if you do that, get ready for a more sternly worded judicial invite.
Or an invite from the Law Society, maybe.
Exactly.
This has been super insightful. Thank you guys. You guys really knock it out of the park every time. I want to thank our audience. There's been lots of questions about the show notes. Go to our YouTube description. You'll find the information there. Okay. Have a great morning, guys.
Good conference, folks. Take care. Bye-bye.